the series of the webinars organized by the Strathclyde Center for Internet Law and Policy. Today we are happy to host Guido, Noto, Diega with an exciting topic, copyright and remote emergency teaching. Guido is an associate professor of intellectual property law and privacy law at the University of Stirling, and he specializes in the legal issues of Internet of Things, artificial intelligence, cloud computing, robotics, and blockchain. Guido's motto, or rather credo, is that the law can and should steer the development of new technologies in an anthropocentric direction. Before I pass the floor to Guido, let me remind you of the format of today's event. Guido will speak for about 25-30 minutes. Then we will have a discussion aiming to end by 1 p.m. GMT. Please provide a summary of your question or remark in the chat box, and you'll be able to ask it directly during the question and answer time. As all other webinars of the series, this one is being recorded. To find out more, visit our YouTube channel. Guido, the floor is yours.
Thank you very much. Thank you, Oles and Angela, for the invitation. I'm trying to share the video. I think screen 2 should do. Let me know. Can you see the slides? That's great. Well, it's great to be here. Obviously, I'm honored because the Strathclyde Center for Internet Law and Policy is really has played a pioneering role in our field and keeps doing so now. So thank you very much. And it's a great opportunity to share some kind of findings of collaborative research I've been carrying out with some colleagues I will introduce shortly. So zooming in on copyright, I would like to start with a quick poll asking people who are listening in how many of you have read the terms of service of Zoom before starting this event, this webinar. So if you want to use the chat function here on Zoom to write if you have read the terms of service and privacy policy, or if you haven't, and I don't know if I can see it somewhere. Suppose there's the chat. Oles, you can keep an eye on the chat and let me know if people are responding to the question, if you read the terms of service of Zoom before joining or not. Oles is not answering, I can't see the chat. But
Guido, I assume the question is rhetorical, and as you can anticipate,
yeah, right, okay.
Only a fraction of our participants did actually read the terms and conditions.
Yeah, well, yeah, thank you. So it wasn't entirely rhetorical, but I would expect some results like this. As it happens, usually we use these online platforms provided by usually US big tech companies, but we don't really know what these companies do with our data and our digital content. So that's where I come from with my interest for this research. Obviously, we're all aware of, for instance, the terrible things that are happening in Hong Kong, and knowing that Zoom, for instance, cut off activists' account in obedience to the Chinese government, for many of us has been disturbing news. But it's not just Zoom that is doing something bizarre with our kind of accounts and data. We know that there are vulnerabilities on Microsoft Teams, or the kind of a phenomenon of Zoom bombing, where people who are not invited to a Zoom meeting, they would join and perhaps sharing pornographic materials and stuff like that without the other attendees expecting that. So there are a number of things that these companies are doing with our data and content that we perhaps don't expect or not are not necessarily aware of. So with a team of people led by Rossana Ducato, who 2 days ago joined the University of Aberdeen, and Giulia Priora, Santana Anna, Pisa, we have decided to look into what companies such as Zoom, Teams, etc. Are doing with our data and our digital content. The reason for this being that you know, when the sort of pandemic exploded, we didn't really have the time to for proper scrutiny. So we started using all these new or not so new pieces of software without really knowing what the companies behind this software were doing with our content and with our data. So the companies, the services that we looked at, you can see the logos here. I don't know if you are familiar with all of them, but I'm gonna read them. We have Zoom, Teams. The third one, perhaps many of us are not familiar with, is actually Google's Meet, and that's part of the G Suite for Education. And then we have Discord, obviously YouTube, Jitsi, Moodle, Facebook, and Skype. So we, this team of people that I briefly introduced, cross-read all the contracts, terms of service, and privacy policy, community guidelines of these services to try and understand sort of their compatibility with European copyright law and European data privacy law. Today we are looking only at the issues of copyright. Perhaps another time we can discuss also the privacy issues. And the sort of these services like Zoom, Teams, Moodle are very different, as you can imagine, but they can all be considered part of what can be called emergency remote teaching, ERT. That is the temporary shift of instructional delivery to an alternate delivery mode due to crisis circumstances. So essentially, this means that due to the pandemic, we had to move all our learning online, all our teaching online, including assessment, and we adopted these kind of online platforms, some of which we were familiar with, some of which we weren't. And usually we couldn't negotiate the contracts with these companies. We had just to accept them as they were, with the partial exception of Moodle. We are not the first ones to kind of look at the copyright issues in emergency remote teaching. So we have, for instance, Professor Odell, Trinity College Dublin, that has been looking at it, and Professor Trosso and Dr. McLem that have been doing so. But these are obviously contributions from an Irish and Canadian perspective, whereas we thought that it would be important to look at it from also from a more generally European and UK perspective. In our view, the UK is still part of the European Union, but we know that's not the case. We are delusional. So we decided to kind of work on this, and at the moment we published 2 blog posts on the Kluver copyright blog, which is quite a good one, and we also developed this into a proper journal article that is going to be published on the European Intellectual Property Review the next month or in 2 months. So so stay tuned, and if you want to know more about the things that we're discussing today, if you just Google emergency remote teaching Kluver, you will find our blog post. In this blog post, you will find very cool things that I'm not responsible for, like this amazing table that was done by Bernd Justin Ute, the University of Nottingham, showing people like which contractual terms are problematic and which contractual terms are perhaps not so problematic. But since I think we have a mixed audience, I don't want to necessarily go into much detail about kind of the small print, but I will kind of mention a couple of terms that I find problematic or even disturbing. So unless there are questions, I will proceed dividing the conversation in 3 axes. The first one is issues of control of the digital content, learning content. The second is liability, and the third is content removal, suspension, termination of accounts. So I will assume that there are no questions and I will proceed. The thing I will sort of dedicate more attention to is the issue of control. Okay, we'll see what it means in. I think it was quite popular in Italy. This advertising in 1994 by it's a Pirelli advertising, and we have the motto that is strength, power is nothing without control. And here, what I want to say is that ownership is nothing without control. Well, I'll explain what I mean by this. When you're using like these new online platforms for your learning, for your teaching, you find that what you own, if you are uploading and sharing content that you own, you retain ownership of that content. So the fact that you are sharing your materials online on these platforms doesn't mean that you're transferring the ownership of this of your material. Let's say that you prepared some slides like I did for today. I retain ownership of these slides even though I'm using them on Zoom, right? So in a way, this might seem reassuring because yeah, we are using our contents online, but we are not losing ownership of these contents. However, my point and our point here is that ownership is not so important as such. So the fact that we own we retain ownership of the materials that we upload and share on Zoom, Teams, and other online platforms. Doesn't mean much if at the end of the day, we lose control over that materials, over that content. And losing control in the field of copyright is something that takes the form of licenses. So by uploading and sharing learning materials and digital contents using platforms such as Zoom, Teams, and Moodle, we are granting a license to the companies that provide Zoom, Teams, Moodle, etc. We are authorizing them to do something with our learning contents. And we will see in a second what we are allowing them to do with our content and our learning materials. So what are the things that, for instance, Microsoft that provides Teams or other companies behind Zoom, Moodle, etc., are doing with our learning materials? They use it, they copy it, they modify it, they distribute it, display it, retain it, host it, modify it, translate it, etc., etc. All the activities that you see on this slide, these are activities that we are authorizing these US companies to do with regards to the content that we are sharing and uploading when teaching and learning online. And I think that's important to keep in mind. That's not necessarily as such problematic, but if we consider it together with the things that I'm going to say in a second, it does become problematic. Indeed, I suppose that the main question is, what are these companies like Facebook, YouTube, Zoom, what are they doing with our learning materials? For which purposes are they using it? The best practice in the field, perhaps unsurprisingly, is the practice of this company, of this service called Jitsi. Jitsi is an open source service. And they say that they use our user content only for the limited purpose of operating the service. Okay, so that's absolutely fine. If I'm using a video conferencing tool, I have to allow the company that is providing the service to use that content to operate the service itself. That's absolutely fine. The problem is that the terms of service of the other companies go way beyond that. Many of them say that they're going to use our learning materials and our digital content to improve the service. Which might seem like a nice thing, but it depends what improving the service means. What are the boundaries of the concept of improving the service? Or even worse, when they're saying that they're using our materials to personalize our experience, it means that they're selling us, they're using our materials to sell us and our students advertising. And do we want that? It's something that we expect these companies to do? Not necessarily. We also know that when we are uploading and sharing learning materials on these platforms, we are often or sometimes licensing those materials to other users of the same software. So if we are uploading something on Facebook, we are also authorizing other Facebook users to use that content. And perhaps the most problematic thing of all in this context is that we are, perhaps without knowing it, because we never read the terms of service, we are also licensing our learning material to third-party providers, to the contractors of the companies like Microsoft and Zoom. Not just Microsoft itself, but also all the contractors of Microsoft. They can do a number of things with our content, including using it for research and development purposes. So you can see how, yes, we are the owners of our learning materials. We retain the ownership even when we upload and share them online on these platforms. But at the same time, we are losing control of this content, of this material. And as teachers, I suppose that, and also students, some of us, we should be concerned about it. You might have noticed that I didn't mention Google and Zoom on this slide yet. Is it a good thing? Absolutely not. Google and Zoom represent the worst practice in the field because they don't even have an express license. They rely on implied licenses, which means that essentially we don't know what Google and Zoom are doing with our digital contents and learning materials when we share them using their platform. We don't know for which purposes they use them. This slide illustrates the qualities of the licenses that we grant to these companies. So the most common license is a worldwide license, which is absolutely fine. These companies are usually in the US. So obviously you have to grant them a worldwide, or at least an international license, because this content is a content that is cross-border, it's used online. So that's absolutely fine. The problem perhaps starts when you start seeing that some of these companies are forcing you to also sub-license your learning materials and transfer it and make it transferable, which means that you can really lose control because you don't know the companies to which your content is going to be sub-licensed. And perhaps the most problematic contractual term of all that we found when it comes to the qualities of the license is the fact that when you use Discord, one of these platforms, you are granting them a perpetual license. So for the rest of your life and even beyond your life, these companies can, this company in particular, can retain control over your learning materials. Obviously, this is problematic for so many reasons, including freedom of expression. So this was my first point, really. I don't know if there are any questions on this. So the first point is that when we upload and share our learning materials using these platforms such as Zoom, Teams, and Moodle, etc., we are retaining ownership of this content, but we are effectively giving up control over this content by means of licenses. We are licensing our control. We are licensing our content to the big tech companies that are behind these services that we are using, and that's perhaps not great as teachers, not knowing what our content, our learning materials are going to be used for. And I think this was the aspect that really made me more passionate, because I think that's really problematic. A second issue is an issue of liability. again, I don't know how many kind of experts of copyright we have listening. So I'm going to say some things that perhaps are obvious for an expert, but the question is, what happens if we upload or share content without the owner's permission? I think as teachers, we know that 90% of the materials that we share, they're not materials that we own entirely. We are relying, we are adding hyperlinks to third parties materials. We are uploading book chapters that someone else wrote, or a video, etc., etc. So teaching and learning really relies heavily on third party materials. This means that in principle, there is the risk of infringing the copyright. And how is copyright enforced? De facto, copyright is enforced in two ways, but usually by means of right holders. So the owners of these of this copyright that ask platforms such as Zoom to remove and disable access to the infringing content. The sort of recent trend in recent years has been that platforms such as Facebook and YouTube are policing our content in an automated way. It's, for instance, YouTube is famous for their content ID system. There is some sort of automated filter that that controls everything that is uploaded on YouTube to make sure that it's not infringing on someone else's copyright. So, and this is in a way, this has been reinforced recently by the copyright in the Digital Single Market Directive Article 17, which is famous for the so-called upload filter. I don't have time, I suppose, to go into detail about this, but just so you know that there is this new piece of European legislation that is going to be implemented by next year, where not in the UK, but in the rest of Europe, that essentially forces online platforms to implement automated filters, preventing you to upload material that you don't own. And this leads to forms of self-censorship. As a teacher, I don't want to risk, obviously, to be found infringing copyright, and I don't want my students, obviously, to be infringing copyrights. So I will self-censor myself. I won't use third parties materials to avoid the risk of being found infringing copyright. Some might ask, yeah, but what's new at the end of the day? Even before the coronavirus, we were using third parties materials in our learning. We were risking to be found sort of guilty of copyright infringement. The truth is that factually there is a massive difference, because what you do in the traditional classroom, these copyright owners, third-party owners, they will never find out. So there will never be, it's very unlikely that there will be a copyright infringement action against you in the traditional classroom. Whereas if what you do online is tracked, is monitored, and therefore if what you're doing online can be qualified as copyright infringement, then that type of infringement can be enforced. And that's obviously that's a problem. So reading the terms of service and privacy policy of all these services, we also found something else that we thought was alarming. We found that teachers are increasingly seen as the new copyright cops. And I think this can be seen, for instance, in this term in Moodle Cloud Service terms of use, where they say that you, the teacher, acknowledge and agree that you are responsible for the acts or omissions of any person using the Moodle Cloud services. So this means that essentially teachers are not responsible and even liable for the content that the students upload. 55% of emergency remote teaching providers extend teachers' liability to content that is shared by their users. This is first obviously unfair on the teachers. I can't see why they should be held liable for something that they didn't do in the first place. And also it's problematic from a right to education and freedom of expression perspective, because we don't want teachers to be copyright cops. That's not the role of a teacher, although obviously a teacher should explain students why plagiarism and other issues are problematic. But these are distinct questions. So I referred before to the issue of self-censorship. To avoid the risk of copyright infringement, teachers can be led to self-censor to avoid these types of risks. These are called chilling effects, and these are made worse by the fact that most companies provide something like this contractual term that you see on this slide. You represent and warrant that your content is original to you and that you exclusively own the rights to such content. So if you are not sure that you actually own all the rights on the content that you want to share, you cannot share it. And you can, as teachers, as learners, that we rely so much on third-party videos and chapters and books, etc. That's absurd to think that you can only share content that you exclusively own. Zoom requires teachers and users more generally to only upload content with the prior written consent of the owner. So before sharing anything, I should go to every copyright owner and ask them to sign a form of written consent for all the materials that I'm using. You understand how this is absurd, and this leads to chilling effects. And I would say most of the companies have similar contractual terms. Team says that you need to have the necessary rights, whatever that means. Moodle says that at your costs, you have to provide them with the titles, with the licenses for the content that you are using. The best practice in the field this time is represented by YouTube, because they say that you can submit content not only if you own the content, but also if you are otherwise legally entitled to do so. Probably this doesn't say anything to a non-lawyer or to a non-copyright lawyer, but as a copyright lawyer, you know that this means this is a reference to the so-called copyright exceptions. So not only you can upload content that you own, but also you can upload and share third-party content that you don't own if you can rely on a copyright exception. For instance, one of the exceptions is the education and teaching exception. I suppose for me, when I teach intellectual property, the thing that I repeat the most is that copyright, although it's a property right, the most important thing about copyright is that copyright is about striking a balance between the proprietary interests of the IP owner and all the competing public and private interests, like the right to access information and the right to an education. So we cannot let copyright become a hindrance to the right to an education. And the main way that the copyright law achieves this balance is by means of the so-called copyright exceptions or copyright defenses. Or three-step test or fair use in the US, depending on where you are. It's called different things. But I suppose the main thing to know is that you don't necessarily need the owner's permission to use material, to upload and share materials if you are doing so for educational purposes. In the UK, the rule has three components. You have to demonstrate that you are dealing with the content in a fair way. So I cannot, for instance, just upload an entire book just as it is. Perhaps I can upload a chapter of it. It has to be non-commercial. So if I'm teaching, usually universities, it won't be deemed commercial, and I have to acknowledge the author unless it's impossible to do so. So this is an example, but there are other similar exceptions that we can rely on when we are learning and teaching online. So we don't need the owner's permission. We can rely on this so-called copyright exception. And the problem is, however, what I was mentioning before about the upload filter and this automated system to find out if I'm infringing copyright. The problem with these automated systems is that they don't really cope well with copyright exceptions, because in short terms, we don't have much time, but you should teach a computer what's fair. You should transform the concept of fairness into computer code for these upload filters to work in an adequate and balanced way. However, I would argue that being impossible to define what's fair and what's fairness, you cannot really create automated systems that work in a balanced way. And this, my friends, lead to forms of overprotection of copyright, and tips the balance between copyright and right to education in favor of proprietary interests of the copyright owners. So this was issue number 2, and I will go briefly to issue number 3. But just to recap briefly, well, there is the risk that that we as teachers are found liable not only for our content but also for content shared by our students. And since this copyright enforcement, it relies on automated systems, there is the risk that our right to education that is expressed by means of a copyright exception will not stand its ground. The third point has to do with content removal. So what happens if you are sharing some infringing material? Let's say that it's unlikely in practice that that as a teacher you're gonna be on the receiving end of an infringement action. For, I would say, for publicity reasons, it wouldn't be great for a copyright owner to bring a lawsuit against you as a teacher. But we cannot exclude it. But what practically is going to happen is the notice and takedown procedure. So copyright owners will file a notice saying that they own the content that you shared, and the platform like Zoom, etc., they're going to take down the content.
Excuse me for interfering. Can you hear Guido? Me neither. Guido? Guido?
Can you hear me?
Yes, now we can hear you.
Live,
so
right.
you were interrupted like 20 seconds ago.
All right. Okay. So before the slides, or
just when you switch to the slide.
Okay. So what I was saying is that although in practice it's unlikely that copyright owners will bring a lawsuit against you as a teacher, although that could happen, what in practice is more likely to happen is that the copyright owners will file a notice explaining that they own the copyright on the content that you uploaded or shared, and the platforms like Facebook, Teams, etc., they will take down the content. That's called notice and takedown procedure. So obviously the most common sanction for infringing copyright by uploading your learning materials will be the removal of the content. And this is obviously kind of a problematic, because when you create an entire module online full of resources, you don't want anyone to take them down for allegedly copyright infringement. Again, because perhaps even though you didn't have their permission, you were allowed to use that material for educational purposes. The second sanction is the suspension of the account. So as a teacher, you could be temporarily locked out of your account for alleged copyright infringement. And you can imagine the distress for you, and how this could affect also the student experience. And what's even worse, most of these companies will threaten you to terminate your account for repeated copyright infringement. So you risk losing everything, because after the termination of the account, all your learning materials would be deleted from the system. So you can understand why a system of counter notice is important. There must be a mechanism, a moment where you are able to actually tell the platform, tell Facebook and Teams, well, even though someone is accusing me to be a copyright infringer, actually I have a right to use this material, for instance, because it's for educational purposes. However, Teams, Skype, Jitsi, Moodle don't have these counter notice mechanisms. So you are in a position where essentially you cannot appeal the decision of the platform to remove the content, suspend your account, or even terminate your account. You can understand how bad that is. So what do I suggest? And then these are the conclusions. I would suggest that we should introduce a right to a human appeal, a right to a human being deciding on our counter notice. So we know that the General Data Protection Regulation has introduced a similar right when it comes a right not to be subject to automated decision, Article 22, when it comes to important decisions taken against us using automated systems. However, the GDPR has to do more with data rather than with digital content and learning materials. So I think that now that is the time to implement in all the member states, apart from the UK, the directive on copyright in the digital single market. In implementing it, we should introduce a right to a human appeal. We have a right to appeal to a human being, explaining why we are entitled to use our learning materials even without the owner's permission. So my conclusion, and I hope I haven't been too long, are I know that they are boring and extremely long, like my slides, but it's important to read the terms and conditions and terms of service and privacy policy of the services that you use, especially if we're talking about emergency remote teaching services that affect the digital well-being ours and of our students so much. So do that before choosing a service for your students. Make sure that that's the best service you can get in terms of the treatment of your learning materials. The second point is raising awareness of the fact that we are effectively losing control over our learning materials when we are using these platforms. Some platforms are worse than others. So again, choose wisely. The third point is that there is the risk that we as teachers are becoming the new copyright cops. And this is a problem in terms of freedom of expression and the right to education. I think it's unfair that these platforms ask us to be responsible and liable even for our students' activities. I think it's important to actually responsibilize and empower students to take responsible decisions. There is a real risk of chilling effects. The fact that these platforms require us to only upload and share content that we own sometimes even with the written consent of the owner, is absurd and is at odds with the copyright exceptions, including the education and teaching education exception. And there is the practical risk that we create a sort of a learning and online learning environment for our students, and for alleged copyright infringement, we lose everything because our content is removed and our account is terminated. So at the very least, I believe that we should have a right to a human appeal against automated enforcement of copyright. And that's me. Thank you.
Thank you. Thank you very much, Guido. It was really illuminating, and you have highlighted so many appealing and urgent problems. It's just a tip of the iceberg, as we all understand. And
thank you.
Let me open the floor for questions. I think we have several already.